Hello and welcome. I am Dong-Yu Cho, partner at Cho Law. As a corporate lawyer licensed in Korea and the state of California, I specialize in helping investors navigate the unique corporate landscape here in Korea. Today, I will be discussing shareholder activism. For some time now, the Korean government is actively working to resolve the so-called Korea discount in the capital market, and a lot of effort is put into strengthening minority shareholder protection. As a result, the environment for assertive shareholder engagement is gaining significant momentum. The high-profile Taekwang case, which I personally handled, is a prime example of this new wave. Korea has a history of high-profile activist campaigns, but the results were often disappointing. Campaigns by activist funds like Elliott and Sovereign against Korean conglomerates such as Samsung and SK were largely unsuccessful. This was primarily due to insufficient protection for minority shareholders under the Korean Commercial Act and courts that consistently took a conservative, pro-management stance. However, the landscape is beginning to change dramatically. Spurred by government initiatives like the Corporate Value Up program, a significant legislative push has led to recent and proposed amendments to the Commercial Act. Notably, these changes have codified the corporate director's duty of loyalty to shareholders and established a clear duty to treat all shareholders' interests equitably and the duty to protect the interests of all shareholders. Against this backdrop, the Trust and Asset Management versus Taekwang industrial case emerged. Taekwang planned to dispose of treasury shares amounting to a massive 24.41% of its total stock to a single, hand-picked entity. This was to be done by issuing roughly $237 million worth of exchangeable bonds. As the second largest shareholder, Truston filed a series of injunctions to block this move, arguing that the action would severely harm the interests of minority shareholders and the company itself. This was the very first lawsuit filed based on the new legal provisions of the amended Commercial Act. As the lawyer personally handling this critical case, I was at the forefront of testing these new shareholder rights. In the Taekwang case, the first instance court ultimately denied our request for a preliminary injunction after nearly 3 months of hearing and deliberation. Regrettably, the decision from the first instance court remains conservative when compared to the proactive movements of the government and the legislature, and conflicts with the legal standards of other advanced nations. And most advanced jurisdictions do not discriminate between the sale of treasury shares and the issuance of new shares when it comes to shareholder protection. In contrast, the first instance court in our case mostly reiterated widely criticized idiosyncratic precedents of Korea without fully embracing the spirit of the new laws or addressing the core issue of how treasury shares are used. However, the legal battle itself opened up numerous possibilities for how shareholders can exercise their rights under the newly codified duty of loyalty, and the first instance court decision is not the end of the story. We have appealed the decision to challenge the outdated framework, and our goal is to continue fighting to expand the domain of shareholder activism and to ensure that the rights of all shareholders are fully protected. The first instance court decision itself is also noteworthy in that it explicitly mentioned that it may be possible to seek an injunction or claim damages against the director based on a breach of the duty of loyalty to shareholders, and that shareholders may file injunctions based on their shareholder rights against the corporation. So moving away from the Taekwang case, what tools do you have to act as a shareholder in Korea in general? The Korean Commercial Act provides a rather robust toolkit. Many of these rights depend on specific shareholding thresholds, and to name a few, they include requesting to convene a general meeting of shareholders, requesting the dismissal of a director, filing shareholder derivative lawsuits, seeking an injunction against the director's illegal acts in advance, or initiating lawsuits to nullify new share issuance, shareholder resolution, or board of directors resolution. Crucially, preliminary injunctions are a powerful provisional remedy in Korea, as sought in the Taekwang case, and they are designed to provide swift and substantive relief, making them a cornerstone of activist strategy in Korea. So in Korea, the era of conservative, protectionist, pro-management policies that largely favored conglomerate owner families is finally nearing its end, and the legal and political momentum is now firmly behind protecting minority shareholder rights. At Choul Law, we are all committed to being at the forefront of this change, and we are ready to employ our expertise and time in protecting your rights as an investor in Korea. Thank you for tuning in today, and please do not hesitate to reach out should you need any legal counsel with your investments in Korea. Thank you very much.